Okay. Hi, everyone. Welcome to the GoldFish Report. I'm your host, Louisa. Today is Friday, March 2nd, 2018. And this is our weekly Country Roads with Winston Shrout. And of course, we have Winston with us. How are you today, Winston?
Well, I'm doing pretty good out here, so I hope everybody else is safe and well.
We're about to have a huge nor'easter on the eastern seaboard. And so I'm glad that we're getting this interview done early today because they're expecting 65-mile-an-hour winds, blah, blah, blah. So the first thing I wanted to mention is Winston's going to discuss today court matters, specifically vacating void judgments. That was a Freudian slip. And really basically using common sense and operating in the court system. But before we get to that, I'm going to make a little announcement. As most of our viewers have seen, I recently published a video regarding the fact that YouTube has deleted our last video, our number 199. But the good news is I'm going to screen share for all of you. I did screen share some of our other sister sites and blogs that you can find GoldFish Report posted on. But this is our website. It is going to undergo some changes. This is the very front home page of the website. And we've had a lot of questions. People couldn't find how to donate. And if you scroll down just a little bit, this orange button right here is a donate button. And you can click there and go right to PayPal usually and make a donation there. But we are also, we are offering options now. We are also on Patreon. So here's our Patreon account right here. And I will also have the link in the description section of the video. So you can become a patron of the GoldFish Report and also receive certain reports and other information before the rest of the public does, or or maybe access to certain other live stream videos or things like that. I don't know exactly sure yet because we're very new to it, but it's a necessary function. It's necessary for us to expand and not rely so much on YouTube, since YouTube is deleting channels, and we hope that they won't be deleting the GoldFish Report. Now, I would like to screen share this. This is BitChute, which is a competitor to YouTube. And as you can see, the missing report that YouTube banned is right here. This is our GoldFish Report number 199. And you can go to bitchute.com, type in the GoldFish Report. Don't forget the is part of GoldFish Report, the GoldFish Report, the one and only GoldFish Report. So make sure you put the in there, and you'll come right to that missing video. So this is where we will be posting companion. We'll be posting simultaneously in YouTube and BitChute. So you can always find our videos here as well as our regular YouTube page. Those are the two new updates that I wanted to share with our viewers today. So you can always know where to find GoldFish Report. If you cannot find us in our normal locations, we're also on Twitter, as you know, and I'll put all those links in the description section. So without further ado, I'm going to hand it over to Winston to get talking about court matters. Thanks, Winston.
Well, okay then. I'll try to move through this quickly because I know you have children in school that you need to go gather because of the high winds. So, this might be just a little bit shorter, so you have plenty of time to, guarantee the safety of your children. Of course, you might bring them home. The storm might come through and blow your house away, but
storm usually comes through the door when they come home. But hey, no, they're good kids. They're really good,
Yeah,
Thanks.
yeah, I know.
But they all bicker. That's just the way it is.
Well, because of the quasi emergency, you might get into some traffic or something. So that's why I say I'll try to get through this as quickly as possible.
Thanks.
So we might not take as long, as we have. Now, some of the subject matter I want to go through today. First is in regards to what's known as vacate void judgment. Now, first off, let me just tell you that anything that comes out of a fiction court is a void. It's a void. And so the only way you get trapped into it is by your acquiescence or your participation in how you handle yourself. And so, there's certain elements that you might understand. And so, actually, the first thing that I want to share is a book written by an individual known as Richard. I think his name is Richard Cornforth. Now, he's a gentleman from Oklahoma. He's been around for a long time. I think I first went to one of his presentation in Las Vegas, probably around, I don't know, 2002 or 2003 or something like that. So I've actually met the fellow, listened to him speak. He's a very good speaker, very congenial. He's not harsh. He's in every respect, a true gentleman. And so, anyway, there have been some recordings of him. Actually, I do on my computer. The thing's too big to share. It's like an 8-hour seminar he did. I have it on my computer. So he's fun to listen to because he's humorous. He's not dull or boring or anything like that. He's fun to listen to. But anyway, he did produce a book, and so I want to share that now. And I'll send you this book because he wants it shared. He wants it shared. So let me just bring up the book, and we'll take a look at some of the.
What's the title of the book there, Winston?
I don't know. Let me find it first.
Oh, okay. Okay.
Yeah.
Okay, go ahead.
All right.
Actually, it's blank.
I know.
Oh, there we go.
Let me just move this a little faster. Yeah. Now, so here's the start of the book. He says, my intention is to inspire users of the book to learn about our legal system and to proceed to fight their own legal wars. So he's trying to prepare people to stand up for themselves. That's what he's doing here. Mm-hmm. He says, although the book is a first step toward understanding our legal system and how to work within it, I advise readers to use the book as a study guide and collaterally research such valuable materials as your local, state, and federal rule guides. I have often been asked, would you be mad if we used your material? My answer is, I'll be mad if you don't. He said, I do, however, caution that before anyone submits any pleadings in any proceedings, it's not merely wise, but mandatory that the local rules are checked. Now, the reason for this is because if you go from court to court, there may be variations. Mm-hmm. Now, you can go to your local, if you're working in a particular court, you can go to, either on the internet or just go to the court and ask them for a copy of their rules. Because they may have, certain forms, they may have, this or that about that. And so it's important that, whatever court you're working in, that you simply just don't go take one of Winston's templates and throw it in there. You go look and see what the variations and so forth might be. Now, I have never brought this up before, I don't think, on these reports, but the easiest court to work in is actually small claim court. The rules, is only usually like 1 page of rules, in small claim. And you notice I didn't say small claims, plural. I said small claim. So anyway, and there's a reason why I would say it that way. But there's a lot of things you can accomplish in small claim court. It's very easy to use their rules. Usually the judge, as it were, the small claim is just an attorney. And it's not nearly as formal as getting into a courtroom with a judge and all these kind of things. So, but anyway, the point that that Richard's making here is go look at what the rules are, with what you're dealing with. So we'll look through this book. There's his full name, Richard Luke Cornforth. Like I say, I believe he is originating from Oklahoma. Just a fine fellow. When I listened to him, speak, first off, he says, I'm not an attorney. He said, I'm not a lawyer. He said, I'm just who I am. I think he had been like a businessman or had been in some kind of, profession like that. But, he tells you flat out, he says, I'm not an attorney. But he says, let me explain to you what I've discovered. So anyway, in this book, it has a table of contents about what you expect to find. So we're going to go through just a little bit of this so you can, have an idea. And then, like I say, I'll send this book to you, and then you can post it along with the video and so forth.
Okay.
So let's look at some of the things. Well, you can see what just in the table of contents, you can see all the different things he's going to cover. Oops. Let me get a little bit smaller here. So anyway, it's a very good book. If you want to study on that. And then not only does he discuss, the theory behind what he's doing, but he also has many, many examples as templates.
Oh, that's good. That's helpful to viewers.
Yeah,
Yeah,
but
that's
again,
helpful.
we always warn people about templates, and so I'll discuss that a little bit more.
You have to
Uh,
change it.
well, it's not just change it; you have to understand it
Yeah, because you
because,
have to put your own information in there. That
well,
might,
yeah, your own information, but you have to understand it.
right.
Because if you're called upon, see, this is the thing that when we get into the last part of my presentation today, I wanted to be able to screen share portions of uh, of a DVD that we had created, myself and Spencer. But as it turns out, we can't quite get the volume to work on it properly. But like Spencer, said, and I've said, same thing. And that is, we can provide templates, we can teach you about this, that, or the other, but you have to internalize it because you create the energy that makes it work. And so if you have a situation, you have to create the energy. It's not Winston, it's not Richard, it's not whoever.
Mhm.
It's you. And so when you look at the templates, that Richard's providing right here, uh, don't use them unless you know what they are. Like I said, well, this one time, when we were working on some unlawful detainer paperwork down there in Las Vegas, the fellow I was helping,
Habeas
uh,
corpus?
no,
You weren't doing
unlawful
habeas corpus.
detainer.
Okay, thought that was
Yeah,
habeas.
so we were doing unlawful detainer down there, and so he had no experience in court, and so but he's a personal friend,
Hmm.
and so I put together again appointment of fiduciary like we usually do, and then answer and counterclaim, like some of the examples I've shown on our reports and so forth, but he studied it, he understood it, so when he put that paperwork into court, he inserted his energy into it. See, if you start to study quantum, or like Scott likes to talk about, he likes to talk about scalar. But in any event, your intention creates substance. Your intention does that, and so Winston's intention might be over here, but when you get into a situation using paperwork that that Winston produced or that Richard produced or whoever, unless you internalize it and you generate the energy to make it work, it may not. It may not. Because when this friend of mine, when he put it in, it worked very, very well. Very, very well. And then someone else that he knew about had a similar circumstance. And so he gave them the paperwork. They just did a name change, put it into the court. Then they went to court on this unlawful detainer in their situation. And so the judge, looked at the paperwork. He asked them a few questions. And finally, the judge said, "You didn't write this paperwork." The judge threw it out.
Oh,
He just
bummer.
threw it right out. And he should have. He should have, because again, I mean, if you're going to put stuff in there, you have to be able to talk about it. You have to.
That's why people have to study this stuff. It is not easy.
Yeah,
I
and
know.
the other circumstance I got into, I told that story, kind of funny story about, going into that little small court, on this code violation, this and that, and how I handled it and how it worked out. Well, another fella in that community, he had a similar thing. I mean, he had a code violation. He asked me what could be done about it. And I said, well, here's what happened to me. And I actually sat down and wrote him out a script,
Mm.
which he memorized. And then when he got to court, I mean, he was giving the answers back and forth, just like on the script, because they asked him the same things. But then they asked him something that they had not asked me. And because it wasn't on the script, he didn't know what to say. And the
Mm.
judge said, if you don't answer me, he said, I'm going to throw you into jail for contempt. And he just stood there like a dummy. He didn't say nothing. The judge had him arrested and thrown him in jail for 3 days on contempt. Now, if he'd only said, I don't know the answer to that question, he wouldn't have been in contempt. But see, again,
Mm.
we can only give examples of how we've handled things and so forth, to assist people. But we can't do it for you.
Right.
We can point you in the right direction. We can help you with your situations and your paperwork and stuff like that. But after everything is said and done, if you don't put your energy into it, it's not going to work.
Yeah, but Winston, I have to say over and over again, you can't wait until you're in a problem. You need
No.
to study this stuff for your own investment in yourself because you'll probably use it at some point in your life, but you can't wait. We've gotten too used to having services available and just, kind of they're there to cater to us whenever we need them. But the fact is that we need to do a lot more for ourselves,
Yeah.
not rely
Yeah.
so much on other people. This is about self-reliance, self-responsibility. Yeah.
Yeah. Okay, well, let's kind of look through this table of contents here. You see, he's got something on the Internal Revenue Service. I don't think that's going to be much of a problem anymore. Like I said, this other report we did, where that fellow from New Mexico had said he had gone past the IRS building and had a police sign up all over it. And then I talked to another friend of mine. He had a friend, this lady, and her husband, worked for the Internal Revenue Service, and apparently they're going to have some meetings come Monday morning.
Ooh, good. That's good news.
Yeah, so in the background, we just hear certain things which would indicate to us that things are changing, and so little by little,
Mm,
they're starting to implement, some of the things that we had talked about in respect to Nasara.
right. Like
And
a
if you
snail
keep up
mail.
with if you keep up with some of the news, you'll see that this Paris, what do they call it, treaty, apparently, finally,
Hmm.
it has things in such a position that Trump is willing to sign off on, and apparently he did. So we expect things, some other things, ancillary things to that,
Hmm.
to shortly go into effect. And so this weekend might be an interesting weekend, put it that way. But anyway, getting on with Richard's book here,
Hmm.
you can see that the various things that he brings up. And so what I want to do, I've gone through some of this and highlighted a few areas that might be of interest to people. Like I say, I'll try to move swiftly through it so we don't get bogged down.
Hmm.
So he starts out secrets of the legal industry. He says we have a two-tiered court system. Now, again, Richard is reporting how he sees things, and so I may describe them using different words. He may describe it using what his experience has been, and then we're going to get into another book here in a minute by another author who sees it just a little bit differently and describes it just a little bit differently. But that's okay. That's what I've tried to do with these reports and everything is to get people to look around to see what's available. And we have some people that have done, absolutely marvelous things in this area, but people just don't know about it. So that's why I try to bring some of these things up. So people would have perhaps a better rounded than just listen to me blabber on and on. So anyway, he said we have a two-tiered court system. He said in our system we have supreme courts and courts of inferior jurisdiction. Says when we were children learning in school, we were instructed that there are three branches of government. Smaller, which is basically legislative, administrative, and judicial. Now, let me express.
Hmm.
If you learned that in school, and we did in our social studies and all that kind of stuff, I remember that stuff.
Hmm.
But the one branch of government they didn't bring up, which is the most important branch of government, is the Treasury.
So there's four branches of government.
At least. But the most important is the Treasury, because none of these people in the legislative or judicial or executive branches of the government work for free, except Trump. Remember, I mentioned Trump don't take a paycheck.
Right. Well, this is why they call it the broken branch. I mean, the whole thing's broken. The tree's
Yeah.
broken.
But
Right?
if you go back to and study the history of John F. Kennedy, he did take remuneration for his service of $1 per year. So anyway, my point being that the Treasury, if nobody gets paid, nobody's coming to work. So anyway, so what we're not told was that the courts of inferior jurisdiction, regardless of their claimed origin, such as United States Constitution, Article 3, Section 1, cannot be presumed to act judicially. Most courts of inferior or limited jurisdiction have no inherent jurisdictional authority, no inherent judicial power whatsoever.
Hmm.
Courts of limited jurisdiction are empowered by one source: sufficiency of pleadings, meaning one of the parties appearing before the inferior court must literally give the court its judicial power by completing jurisdiction. Now, you call that last report we did, where I showed that one skeleton, uh, a suit for recoupment. What was the first thing on that? Jurisdiction and venue.
Jurisdiction. Yeah.
Yeah, you have to give it to them. Yeah. So anyway, federal courts also are courts of limited jurisdiction and may only exercise jurisdiction when specifically authorized to do so. A party seeking to invoke a federal court's jurisdiction bears the burden of establishing that such jurisdiction exists. So you can't just walk into court and start, yammering. You got to set things up. That's basically what Richard's saying here.
Most people yammer.
Yeah, we got a lot of yammering going on
Yeah,
down there at the
yes, we
courtroom.
do. Poor people. You know,
And then he goes through the different, sites, that you can look up to verify just exactly what he's saying.
I've done some yammering myself, Winston.
And a lot of people
As
do.
as you know, I was in a trial for almost 20 days, and most of those days I represented myself. I was on the stand representing myself, so I know what yammering's like, and I know how
Yeah.
you can get yourself into trouble. But it's ignorant. We're ignorant of this. That's why
Well,
it's
yeah,
so important to share this information with people.
a good part of yammering is just hearsay anyway. And
Right.
so we do way too much talking, way too much. Anyway, let's go on here. He gives the example of Oklahoma. That's where he's from.
He's
He
an oak.
talks about the sufficiency of pleadings,
Uh-huh.
so forth. Okay, so let's move on a little bit here. Let me kind of bring this down a little bit. So I don't. Okay, he says, I hope by now everyone understands that a court does not get its jurisdictional authority from the flag that's posted. I mean, everybody, a lot of times, gets going on and on about the flag. Anyway, this was an issue way back, when Richard, was putting some of these things out and doing workshops and seminars and things. Anyway, courts of inferior or limited jurisdiction get their authority from one source only, and only one source: pleadings sufficient to empower the court to act, meaning one of the parties must give the court its power to act by way of written and oral argument. The parties, this is the point he makes, and a lot of people don't understand this, but the parties, not their attorneys, must do this. And see, an attorney can't give a court jurisdiction. It takes the parties. Yeah, well, then he talks about, common law court system, talks about the development of what people call common law. The superior court is a common law court that operates in a system that has little federal common law. First off, technically, there's no such thing as federal common law. Common law comes from people, right?
Sure.
Yeah. So the federal, which is a fiction, technically, there's no such thing as federal common law, although they have bootstrapped their way into that. Then he said, yet its common law nature is important to the court's functioning as a constitutional arbiter. Common law is a system of law made not by legislatures, but by courts and judges. Okay, common law is not law that's been legislated. Now, I think we had talked in time past about statutes at large, the proper enactment to create liability in people, so forth, which comes from the legislature. But if you look at our court systems now, it all operates on precedence, usage. For instance, you go to the law library and they got books and books and books about different court cases that were settled and so forth. Just watch the attorneys. Say, well, we're basing what we're saying on this court case that happened over here and wherever.
Right there.
They go back and forth, all that foolishness. Mm-hmm. And even if you look in the law books, which are only a summary of the court case, somebody has summarized that, and they've only picked out little pieces of it.
Yeah.
That's why I would never cite any court case in defense of anything I was doing. First off, it don't apply to me.
The circumstances are always different, yeah, but that's what they do. It's case law, it's called.
Case law. It's legislation of law from the bench, right, from the court. And the courts are not there to do that. For instance, like I say, I mentioned that one fellow I knew who had, run a court case, and he had gotten it all the way to his case became a precedent. And then the more he looked at it, the more he realized he was wrong. But now he had already pushed it as a precedent.
Yeah.
And so bad law, if somebody relied upon that precedent, it was bad law. And he knew it.
That's the problem. Yep.
But he couldn't get rid of it at that point. And so, like I say, unless you actually read a case from start to end, you can't rely upon the summaries. And it's done all the time. And so, people really need to take a close look at that. Anyway, said in common law, the substance of the law is to be found in the published report of court decisions. That's common law. That's why, I had said, I just don't like to hear all this yammering about common law. It don't make any sense to me. Anyway, it says 2 points are critical to the workings of the common law system. First, law emerges only through litigation about actual controversies. Second, precedent guides courts. Holdings in a case must follow previous rulings if the facts are identical. Well, first off, let me say the facts are never identical. So.
Yeah, but that's how they decide cases today. It's not even really what's on the books. It's what's been decided previously. And that's case law. You have to have really, and not only that, but if you're in the appellate court, you can't use a lower court ruling. You have to use at least appellate or superior court. Supreme Court of the state you're in order to have, right, Winston, in order to have that, I guess, more higher authoritative ruling on it.
Yeah, really.
Higher authoritative.
Really higher. In any event, first off, Richard is approaching this from a typical point of view. Now, would I do things the way Richard does them? And I would say probably not. But what I wanted to expose people to is the concept of vacating void judgments, because I keep, people keep coming and saying, well, Winston, I got ruled against over here, and I'm thinking about going over here and doing an appeal, or I'm thinking about doing this, that, or the other. So, well, why don't you just go vacate the void judgment? Why take something to appeal if you can vacate it right there at the court you're in? And so what Richard is showing in this particular book, among other things, is how to vacate void judgments, which we're going to get into here, just in a few minutes. So he's giving a little, work up to it so people will understand. Then he talks about Constitution. Like I say, I'll send you this book so you can have it.
So when you say he talks about Constitution, is this the groundwork for what's coming, what's about to proceed from this? Is he giving the background, the basis for this vacating the order, the void judgment, rather?
Yeah, he's giving people just a little bit of education, so that when he makes assertions about void judgments and so forth, it make a little bit of sense to him.
Okay.
So Richard is working completely within the system.
Mm-hmm.
Like I say, he's not an attorney, but he puts attorneys to shame. So anyway, let's see. Like I say, I'll provide this, and people can study and look at it. Now here's something interesting that he points out. He says the real law is found in the annotated statute. And so he gives an example of a United States Code annotated that you can learn from. But all I want to do is point you down here to the copyright. Don't you know that all the statutes, all the precedences, all these things are all copyrighted? And so if you use copyrighted material, what are you doing?
You're violating copyright. You're infringing on copyright protection.
You may be. If you use the copyright to make a profit.
Oh, right. But
that's a copyright infringement. So guess who copyrighted this? It's Westlaw.
Yeah.
Westlaw Group. Now, and actually Westlaw, the copyright itself, is held by a corporation or a company. I think they're down in Arizona. And so it's kind of funny. One time I showed this. I looked on my computer to see if I can find this company again. I ain't looked at it for a long time. I couldn't find it right off, or I'd had it for you. But anyway, it's actually a corporation or a company. I think they're in Arizona that actually owns the copyright.
Well, there's also fair use laws too.
Yeah, but not to make a profit.
Well, who's making a profit? You're usually.
Well, if you go sue somebody and you use some of their copyrighted material to do it, you just made money on it. That's copyright infringement.
If you sue someone, you're looking for damages. You're looking for
exactly.
loss,
but if you use their precedents that's copyrighted, that's copyright infringement. If there's money involved.
Those suckers. I'm sorry.
Well,
that is terrible.
What I did was a friend of mine, he was in some kind of a suit in court, stuff like that. So I pointed this copyright out to him, and then I supplied him with the name of that company, that owned the copyright. So he wrote to him. He wrote to him and said, would it be okay with you if I use your copyrighted material in this case? And they wrote back and said, yeah, it's okay, go ahead. So when he went into court, he produced that letter from the company that owns the copyright and says, well, Judge, he said, I got permission to use these copyrighted materials, but does this attorney over here have it? You're just messing with him. But again, he actually went to the copyright owner and said, can I use your copyrighted material in this court case over here? And they gave him permission to do so. I mean, okay, is all that necessary? Probably not. I'm just pointing things out that people don't see.
Right, exactly.
All these codes and everything are copyright material. Okay, I don't want to, work that up too much. I just wanted to point that out. No, people are not aware of that.
No. Okay.
Tell me when.
We're ready. Mhm.
Oh, we're
Let's
back.
take a little
Okay. All
break.
right.
Yeah, we had to take a little break. That's okay. We're back.
Yeah, that blow my nose a little bit.
Okay.
All right. But anyway, we just have finished up with looking at what Richard was pointing to about using the annotated code, where the real juice is, if you want to call it that.
Okay.
Anyway, he goes on talking about, says there's two types of jurisdiction relating to people. Number one is personal jurisdiction, is lawfully exercised over the defendant if the person lives in a jurisdiction, operates a business in a jurisdiction, owns property in a jurisdiction, or commits an injury in the jurisdiction and has had notice and opportunity. In other words, they're in receipt of proper service. If these elements are complete, personal jurisdiction cannot be denied.
Mm.
Now, he says even if these elements are lacking, personal jurisdiction can be waived by appearance accepting a person not represented by counsel entering a special appearance for the purpose of challenging the court's personal jurisdiction. Now, this special appearance, again, we had talked about that a little bit. Special appearance can be found in the Federal Rules of Civil Procedure in the appendix. It's called pleading special matters, blah, blah, blah. And it talks about making special appearance and so forth. And in your state code, you'll find the same thing. So by entering into a court and announcing that you're making a special appearance, you are not acquiescing to the jurisdiction of the court because you simply showed up to say, hey, something wrong with what you're doing. I don't know, I don't know where you get off doing what you're doing, but I'm here to challenge it. And so by making a special appearance, you're not granting jurisdiction in personam.
Mm.
See? Okay, then he goes into subject matter jurisdiction, and he says subject matter jurisdiction is the court's power to hear and determine cases of the general class or category to which proceedings in question belong. The power to deal with general subject involved in the action. Subject matter jurisdiction can never be waived. Okay, so what he's saying is subject matter jurisdiction has to be established. You can't waive it. So subject matter jurisdiction can never be waived, cannot attach by mutual consent of the parties or lapse of time or course of events other than sufficiency of pleading. Once established, subject matter jurisdiction can be lost.
What does he mean by that?
It
I mean,
means
can be lost. I'm not sure what that means.
well, it means that if subject matter jurisdiction has been established at the start of it, it may be that the subject matter jurisdiction can be lost. Well, the ultimate extreme is that, the subject dies.
What do you mean? The case can be lost? Or the
No,
jurisdiction?
the jurisdiction can be lost. See, he's saying there's two kinds.
Yes, I understand that.
There's in personam or there's subject matter jurisdiction. Now, so at this point right here, he's saying that even if subject matter jurisdiction has been established, it can be lost.
Okay, got it. And then it would revert back to personal jurisdiction.
No, then the case would have to be dismissed.
So you're saying that the case can be lost.
Yeah. Mm-hmm.
So that's much more risky, it looks like.
No, it's a whole lot easier to work with.
I'm sorry, I'm lost. I hope our viewers
All
bear
right.
with me.
Well, you just have to study the concept.
I understand.
So he says when subject matter jurisdiction is challenged,
Okay.
the party asserting that the court has subject matter jurisdiction has the burden of showing that it exists on the record.
Yeah, we have to study this stuff, folks. We have to study this.
Well,
Knowledge.
once the court has knowledge that subject matter jurisdiction is lacking, the court, meaning the judge, has no discretion but to dismiss the action. Failure to dismiss means that the court is proceeding in clear absence of all jurisdiction and subjects the judge to a suit. He's going to get sued.
Mm-hmm.
So subject matter jurisdiction is a really important concept, for people to understand. And
Okay.
okay. So again, let's go back to some of the scenarios we've talked about. Like say, for instance, dealing with the third party debt collector.
Mm.
So they sue a case. They bring in their information, and all that kind of stuff. You do a subpoena ducis tecum for any and all original signature documents that proves that the defendant has a liability to the plaintiff. And when they can't do that, what happens? They lost subject matter jurisdiction.
Okay.
What has the judge got to do?
Gotta throw it out.
You got to throw it out. See, these are just some of the things that we've developed over the years that are simple. They're simple. So anyway, he goes on, talking about various things there, and says, okay, now here's the next part that the people really need to pay attention to. Attorneys can't testify.
Nope.
Statements of counsel in brief or in oral argument are not facts before the court. And you hear these attorneys get up and start reciting all kinds of things and making all kinds of allegations and accusations and all this kind of stuff. You need to object to it when they do that.
Right. It's
the objection is facts not in evidence. Attorneys are getting up and trying to persuade the court or try to persuade a jury or something like that by making all kinds of outlandish statements. They can't do that. And when they try it, which might have the tendency to prejudice the case, you need to object to it, and the objection is facts not in evidence. I mean, that's just a short way of saying the attorney has no firsthand knowledge, judge, tell him to shut up.
right.
They do it all the time.
Yeah, they do.
Anyway, goes on, as we have said, of other unsworn statements that were not a part of the record and therefore could not have been considered by the trial court. And then he quotes, from this case here, it says, manifestly, such statements cannot be properly considered by us in the disposition of a case.
Hmm.
See? But you see attorneys doing this all the time. They're trying to prejudice the court.
Oh, and they do it too.
Oh, yeah, they do it. That's why you have to object. Now, one of the things, and I've referred to this once before, and people need to go look up a word called barratry. Barratry. Now, what the word basically means is making an argument, where there's no argument. Now, in other words, one of our maxims, and this is one of the things, that I like about Spencer, is he always goes back to the maxims.
Right.
And once the thing's been settled, it's settled. And you can't raise an argument about something that's been settled. Now, in commerce, we talk about estoppel, creating estoppel. But anyway, once a matter's been settled, it's settled. You can't bring it back up again, but the attorneys love to try it. They love to try to do that. And so they get up and start some kind of argument about something that's already been settled. That's called barratry. Hmm. It's making an argument where there is no argument to be made. And so if an attorney were to try that, you would state, to the judge, objection, Your Honor, this is a matter of barratry. And so the judge should tell the attorney, don't do that no more. If they do it the second time, it's a crime. And so the first thing you tell, the first time they try it, you tell the judge, well, judge, this is my first warning of barratry. My first warning of barratry. If they do it again, then you just tell the judge, this is my second notice of barratry, and under the doctrine of misprision of felony, you better do something about it, because you don't, I'm going to sue you. See, because the attorneys are trying to prejudice the court, or if it's a jury or something like that, they're trying to prejudice the jury in their favor, even on a matter that's already been settled. Attorneys work in the world of arguments. That's all they know how to do is argue. I mean, what happens? You got 2 or 3 kids on the playground, and they're arguing over a jump rope or marbles or whatever. What would a reasonable adult or parent do? Stop arguing. It's already been settled. You know, the marbles belong to so and so. The jump rope belongs over here. See, but you know, we find the same thing in our court system. They act like little kids. They want to argue about everything. You know,
Unbelievable.
they're not looking for justice or the facts in the matter. They just want to argue about stuff.
Mm.
So when they start that crap, then you have to put an end to it, plain and simple. Okay. Anyway, says you know, talking about this court case and some of the things. Says under no possible view, however, of the findings we are considering, can they be held to constitute a compliance with the statute, since they merely embody conflicting statements of counsel. So the attorneys get up and argue with one another. Well, that's fine. You know, you might well just take it out in the hall if you want to argue about it. But what good does all this arguing do? You know, see, they're just trying to prejudice the jury or the judge. So you got to jump on it. All right. Let's see. Let's go along here. I've highlighted. Now, the next thing is factual statements or documents appearing only in brief, which is, you know, your filing and stuff, shall not be deemed to be a part of the record. Okay, what is the record? That's the important thing we're going to. Remember how I told that all these courts, you know, operate as administrative, and the guy sitting up front is an administrator, not a judge, until what?
Until he acknowledges he has an oath.
No, well, it could be part of that, but until he has facts in evidence, then he turns from being an administrator into being a judge, because he can't be a judge until he's got something to look at.
I know, but people can submit. I mean, how do you determine what a fact is? It's really
Okay, evidence rules. Go to your court that you're working in and see how you go about creating the record. And it's through the evidence rules. It's not hearsay. You know, what you put on paper is nothing but hearsay. It's jabber.
Yammer. They're yammer.
Yeah, you're
Jabber.
yammering. You're yammering.
We have a whole glossary of Winston terms.
Yammering, huh? Yeah. Like your word. Anyway, if you look at, you know, basically, if you look at your rules, you'll find there's 3 ways to create the record. Number 1, you have to take the witness stand, because it has to be sworn. It has to be sworn testimony. In other words, you got to be liable for what you're saying. And so you take an oath. An oath that what you're fixing to say is the truth. And so then you give your evidence either by sworn testimony or by affidavits presented to the court from the witness stand under oath. That creates the record. And now that you have created the record, the guy sitting up front is no longer an administrator, he is a judge. And he better act like it. Because if he don't, he is risking his bond. He's risking his job. He's risking his job. So you see why it's so important, if you're working on a case, that you get things into evidence. Make the record. Now, one other way that you can do that, a lot of, you know, I've talked about this a little bit, but you can make the record right from the floor of the court. And the way you do it, like I've told people, you know, if you have something, you know, that you need to put into the record, just, you know, ask for permission to speak, and then just put your right hand up to the square. That's a sign of swearing. Put your right hand up to the square, say, for and on the public record, you know, blah, 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 blah. And that goes into the record. That's evidence. So you can do it that way. The next way we like to do it, like I said, well, I won't go into some little funny
Why
things
is
we've
it
done.
why is it the right hand? And why do we always see like in
History, history.
but why do we
Right, right hand to the square. See this?
yeah, yeah.
Right hand to the square. That's our history. That it historically, that's the sign of the Levitical priesthood. Historically,
Yeah. You see a lot of
so that's
historical pictures of back even with Sumerians and ancient Egyptians with the right hand
yeah.
up. Yeah.
Uh-huh. Yeah, so that's the sign of the Levitical priesthood. The sign of the higher priesthood of Melchizedek is both arms to the square. You
Really?
remember?
Like this? Like both hands up? Like
Yeah.
I surrender. I'm under arrest.
Okay. Not surrender.
Oh, sorry. Well, when the
It,
police tell you to put your hands up, you go like that. I mean, not that I would know. Thank God.
no, if you remember that story, I think it was Moses and the Israelites out fighting a battle or something like that. And as long as he had both hands to the square like that, they prevailed. But if he got tired and dropped his arms,
Oh.
they started to lose. And so they had a couple of guys stand there to make sure his arms stayed up.
That's quite funny.
Well, it is historical. It's come down to us. Like I say, we've tried to give as much history about things. And so
Yeah,
you asked me about why is that? And I said,
yeah,
well, it's historical.
right.
This is the way we've done things, for millennia. Okay. Getting all the way back to Moses and whatnot.
You got
All
that
right.
chemtrail cough back there, Winston. They keep us
No, no.
spraying you guys, huh? They spraying you guys still over
No,
there?
I picked it up. I can't get rid of it.
Uh,
Anyway, don't send me any remedies, folks. I got enough remedies as it is. None of them are working, so don't send me no more. All right. Okay, well, let's get on a little bit further here. It says, now he gets into this part here, section 2, the law of voids. He said everything you always wanted to know about void judgments, but were afraid to ask. Like I say, Richard's a real humorous fellow. He likes to make, a little tongue in cheek,
mhm,
thing stuff. Anyway, it says void judgments are those rendered by a court which lacked jurisdiction, either of the subject matter or the parties. Okay, so he's telling you what would constitute a void judgment.
mhm,
So let's say, like I had mentioned, subject matter jurisdiction can be had and lost all through a case, actually, all
mhm,
through a case.
mhm,
And so if it gets down to the point where it's obvious the subject matter jurisdiction has been lost and they go ahead and render a judgment on it anyway, what is that?
mhm.
It's void. And so what Richard is talking about, how do you go about dealing with a void judgment? So that's what this part of the presentation that he's putting on here is about. It's the main thing. See, a lot of people, okay, it's not over till I say it's over.
Yeah, got it.
And and like a
But he's
so
citing. He's. I'm sorry. He's using case law though here to cite.
well, yeah, he is like I say, he works inside that system. I mean, I wouldn't state it. I wouldn't state it precedent. I just say it.
Mhm,
But anyway, for instance, I kind of jokingly talk about Roger Elvey, and I know he's working on a case that's well over 20 years old. Because it's not over till Roger says it's over. It ain't. Oh boy, I tell you what, man. Some of the things. Anyway, I'm not gonna get into the Roger stories because I'll start laughing again. But anyway, one of our commercial maxims is he who leaves the field of battle first loses by default. So if you have a judgment come down to you and you don't do anything about it, then you just lost because you have abandoned your position. So what Richard's trying to do here, he's trying to show you how to go and deal with something like that, because he's going to explain to you about void judgment. And like I had mentioned, anything that comes out of the fiction court on its face is void. On its face is void. But anyway, but then he goes through, talks about void judgments, He says a void judgment is one which, from its inception, was a complete nullity and without legal effect. The void judgment, and then he goes on about, I don't know, about 10 or 15 different uh, statements here about void judgments.
Mm-hmm.
So you can go and read all this stuff, and I mean, obviously he thinks this is an important thing because he just pounds the heck out of it.
Mm-hmm.
So
Yeah, look at this.
all these things I've highlighted here, he's talking about what a void judgment.
Is this guy still around?
I don't know. I haven't heard anything about him for a long time.
Hmm.
Maybe he went back to farming. I don't know. Like I say, I did go to one of his presentations in Las Vegas, way back in the early 2000s. I haven't heard much, about him since.
Oh,
But he wrote this book and he wants everybody to have it.
good. Okay.
Like I said, I watched that one. Like I say, I've got a copy of one of his 8-hour seminars that he put on.
Hmm.
And he said, he told the people at the seminar, he said, go out and teach this to 300 people.
Yeah.
So he wants this information out, and that's why he wants this book spread. So like I say, different people have written to me about circumstances and stuff. I said, well, let me send you this book that Richard wrote on void judgments, and maybe you can figure out how to make that work in your particular situation. You see, and then here in a minute, you're going to see that he has created, several templates,
Hmm.
that you can look at, and you can use the templates to create your own court case and stuff like that. But again, if you do that, make it your own work. You have to understand it. Otherwise, they just throw it out of court. Like I've told people, when you create paperwork, you're sitting at your computer, and you're doing this and that, and then you print it out and all that kind of thing, and you anticipate putting it into the court. The energy that you have already created precedes the paperwork to the court. Your energy precedes the paperwork.
Mm-hmm.
You see what I mean? So when you start talking about energetics, paper don't have any energy unless you set fire to it and it burns and you can warm your hands with it. Paper don't have any energy, but you have the energy. And so you insert your energy into the paperwork, and your energy will get to court before you ever get down there to file it. Think about that. It's really important. Anyway, he goes on and on about, void judgment. So you can just read all those and satisfy yourself. You understand what it is. And he keeps going on and on about all the different circumstances that would create a void judgment. Look at it. You got 2 or 3 pages of it here. Now, don't you think you could find at least one thing, in all that might have application to what you're dealing with? You see what I mean? All right. Well, let's keep going here. Like I say, I don't want to beat this to death.
Yeah, it's bringing back a bad memory for me, actually, at this moment.
That's what I'm saying.
I know, it's kind of not a good thing. Because they're lying thieves. I mean, what people do in courtrooms is unbelievable. The way they, and they get away with it. And that energy, it's like what happens to you walk in and you try to be as honest as you possibly can. I mean, and, you're honest to the best of your recollection. And, you have a counterpart that's, like really a pathological liar. But they're so cool, calm, and collect,
Well,
and you are too, but you're telling the truth. So, truth has a resonance, truth has a frequency, and
like I
they know
say, when Richard gets a little bit further down here, now he does, in this particular book, he does have examples of how to do an appeal. I personally would not want to do an appeal. I would go for void judgment. Now, like he points out, there's 2 ways to attack a void judgment, and we're going to get into that a little bit here. But the 2 ways are direct attack, which would be in the same court that you just got screwed in, or a collateral attack, which is preferable. For instance, somebody called me up the other day talking about some kind of court case, and they got ripped on it and all that kind of stuff. And they said, well, what could be done? So I was talking to them, And I sent them a copy of this book so they could look at all this void judgment stuff.
Mhm.
But I said, make a collateral attack. They said, how would I do that? I said, go sue the case. In other words, so over here in this court, it was case number 1, 2, 3, 4. I said, go and do a civil suit against case number 1, 2, 3, 4 and serve the clerk of the court. That's what's called a collateral attack. A collateral attack. In other words, you're attacking from the side. And any good soldier,
Mhm.
or Marine will know what a pincher movement is. In other words, you got some battle going on right here, and what do to overcome the enemy? You do a flanking maneuver.
Come in from the
That's what's
side.
called a collateral attack in our what we're talking about here, collateral attack. We'll get to that just in a minute. Okay, let's see. I don't know how much of this. Okay, here's a summary. Before a court or a judge can proceed judicially, jurisdiction must be complete, consisting of two opposing parties, not their attorneys. Although attorneys can enter an appearance on behalf of a party, only the parties can testify, and until the plaintiff testifies, the court has no basis upon which to rule judicially. And the two halves of subject matter jurisdiction, the statutory or common law authority the action is brought under, which is under the theory of indemnity, and the testimony of a competent fact witness regarding the injury. You remember, I listened to some of that stuff on YouTube, Trey Gowdy. He really getting after somebody. I forgot who it was exactly. He getting after him. He said what? He says, you've removed a fact witness. And he was indignant that they had done that. And so who he's yelling at there basically had tried to remove somebody that knew the facts in the matter so they couldn't be gotten to. And Trey Gowdy were ripping them for it. Says, you've removed a fact witness. How
Yeah.
stupid is that?
Trey's the prosecutor. That's why he resigned from Congress. So he's going to be going after these military tribunals that are supposed to, we
Yeah,
hear are setting up. Trey's going to go, he's going to be in his glory. I think he really loves being a prosecutor, and that's where he
I think
wants
so.
to be. Yeah.
But he seems to be a real honest fella.
Oh, yeah.
Hey,
Integrity.
I like to listen to him. He's just a
Yeah.
plain talker. He said,
Oh, yeah.
he's really not political.
Isn't he from the South?
I think he's from South Carolina. They said.
Oh, right. That is his district, South Carolina, I think. Yeah.
Yeah. Anyway, he says if there is a jurisdictional failing appearing on the face of the record, the matter is void, subject to vacation with damages,
Mhm.
and can never be barred. In other words, if something is void, they can't stop you from vacating it.
Mhm.
Anyway, then he makes a kind of a little statement here about all void judgments. Okay. He says, so how do we vacate void judgments? He said, we petition to vacate them, we sue them. All right. So then he gets into talking about collateral attacks. He says, this is known as collateral attack, or a pincher movement for all you soldiers and Marines. It's a pincher movement.
Mhm.
Sometimes a direct attack is appropriate, but not usually. A direct attack goes back into the same court where judgment was obtained and likely to be the same judge. Oops. Obviously, it is usually most beneficial to do a collateral attack, sue them. Sue the party who got the judgment against you or your friend. Also, after we get the judgment vacated, it's almost always moot and can be reasserted, especially if beyond the statute of limitations. And please remember, statutes of limitation do not apply to vacating void judgment.
Okay.
Roger's working on one that's 20 years old. Oh,
Hey,
no, there's no statutes of limitation on voids.
yeah. So, but when you say sue them, under what, so that doesn't tell anybody, are they going to go into this a little bit more? Richard going to go into this more? Like,
I just did.
by sue them?
I talked about somebody that called me up and said, we got this judgment against us. What can we do about it? And I said, well, I'll send you a copy of Richard's book
No,
here.
I
No,
meant
no,
what
no,
grounds?
no,
What grounds?
no. What?
What grounds do you sue
Then
them for?
it's void.
Okay. I've,
Again,
I'm
like
trying to just help the viewers understand, Winston, because it's not
anything,
necessarily clear.
anything that comes out of a fiction court is void on its face, period.
Okay, there you go. That's what I was looking for.
Any of it.
To avoid, even if you unwittingly participate in it
Or acquiesce to it
and
because you just
consent,
don't know.
right, or consent, right, to agreeing to acquiescing to their
Yeah.
jurisdiction. Yeah.
So like I told this other guy, I said, well, just go sue the court case and serve the clerk of the court under a collateral attack.
Mm.
Well, for instance, we talked about habeas corpus. Habeas corpus is a civil suit. It's a collateral attack. That's what habeas is. It's a collateral attack. It's a civil suit.
Okay, Winston, these are just absolute,
Well,
right, put the weapon down, Winston. No, he's got his weapon. He's a Marine. Winston's a Marine. He's always now. Look, attack. Okay, I just want to help connect the dots for viewers because you have to have the right background information. As you said, don't go into the court until you really understand what it is you're doing. So that's what I'm trying to just make sure they're connecting the dots. They need to have that background information and the premise that this is void. Well, why are you saying it's void? You signed to this. I mean, they're going to try to trip you up. They're going to try to question you and make you feel like you don't understand what you're saying. This is what they did to me. So I know, but I was, careful. So I could be.
Well, I'll tell you a funny story. This story was told. Did you ever hear of a comedian out of Mississippi called Jerry Clowers?
No.
He's dead now.
No.
But he used to tell some of the funniest stories. And one of the stories he talked about was this fella. He was some kind of a professor. He was an expert on oil drilling or, geology and all that kind of stuff. And so he was going around the country. I mean, the big oil companies hired him to go around the country and give a presentation. So after and they gave him a chauffeur to drive him around. And so, so anyway, after this fella had given this presentation, 3 or 4 or 5 times, the chauffeur was driving around and said, "Listen," he said, "this is not fair." He said, "They're paying you all this big money to go give these speeches and everything." He said, "I'm chauffeuring you around." He said, "I'm not making very much money." He said, "But you're making a whole lot of money." He said, "This ain't fair." He said, "I've heard this thing so many times." He said, "I can repeat the whole lecture myself." So the professor said, "Well, okay." He said, let's just change places. So they made it up like the chauffeur was the professor, and the real professor put on the chauffeur's hat, so they went into this. And so sure enough, this chauffeur got up, he made the speech just exactly like the guy had made it. And
Funny.
so the real professor was sitting in the back, had the chauffeur's hat on and all that kind of thing. And so after he made his speech, they started asking questions.
Ooh.
And so somebody asked him some kind of question about, geology and this, that, and the other, which he didn't know. And so what this guy said was, he said, "Well, you know what?" He said, "I'm really surprised that a man of your education would ask a simple question like that." He said, "As a matter of fact, that question is so simple, I'm going to have my chauffeur answer it."
Oh, it is fun. That guy is so, whoa, that's a quick thinker, huh? He must have had
Yeah,
that prepared and ready in case he
yeah,
was
he
going
did.
to be asked questions. That's funny. That's really
And
funny.
well, that was a story about Jerry Clowers. He
That's
tells some
funny.
of the funniest stories you ever can
That's
imagine.
pretty funny. What
Yeah,
characters, and you meet Winston, real characters.
yeah, yeah, yeah. But
That's good.
anyway,
That's good though, because they're real
yeah,
genuine people. That's what makes them characters and makes it fun to learn about them.
yeah. But you were complaining they was asking you a whole bunch of questions. Just tell them. Listen. First off, you don't have to answer any question that anybody asks you. You don't have to answer it. You might just come back and say, "Well, that question is so stupid, I'm not even going to try to answer it." Have you ever said that?
In a court?
Anytime. Yeah, in the court,
In a
attorneys,
courtroom.
whatever.
Uh,
Well, a lot of times you just look at the judge and say, "That's not an appropriate question. It's off subject. They're just trying to start an argument. That
yeah.
matter's already been settled. This is a question that would incite barratry, and I'm not going to answer it." You don't have to answer it. You don't have to answer anything. People just jabber and blabber like crazy. You know, think about this: the less said, the best said. When you get into these situations, but let's move along. I'll see if I can find a chauffeur to help you out a little bit. Okay, so here he's going into some typical uh, templates. Yeah, Robert is smart.
What
Ben
a
Dan.
character this guy is.
Yeah, he got a great sense of humor. I like to listen to him. He's fun to listen to.
Claire, bad girl, very very cute.
Anyway, so this is a verified petition in the nature. Okay, see,
Yep.
we like to do this in the nature of.
Okay.
So a verified petition in the nature of a petition to vacate a void judgment and collateral attack under authority of Oklahoma Statute Title 12, Section 1038. Now, what I want to point out here is the word verified. And the reason I do that is because look down here at the end of his pleading, guess what? It's verified. This is an affidavit. This is an affidavit pleading. You remember how many times I have suggested to people when you put pleadings into the court, put it in affidavit form. That's exactly what Richard has done here. He has a verified petition because he has his autograph notarized. You see, okay.
Yeah, flashback time.
Now what is the beauty of doing that? Attorneys can't rebut an affidavit. They have no first-hand knowledge.
Experience. Exactly.
And so to overcome this particular pleading that Richard has put together here, I mean, the attorneys can set up and jabber and argue about it all day long if they want to. But what would they have to do to overcome Richard's pleading? They'd have to bring in at least two witnesses. The scripture says two or three. They would have to bring in at least two witnesses
with first-hand knowledge.
To they could overcome what he just put into this affidavit pleading. You see why we do that?
Yep.
Yeah, I see people putting stuff into court all the time. It's not verified. Nothing. Okay. Well, again, like I say, he has several different things here to vacate. It might have to do with third-party debt collector. It may have to do with the IRS, whatever. So he's got a whole bunch of a whole bunch of templates here that you could look at and learn from, and you can use these things. Here's got one, for quiet title action. I don't want to get into all that, but I'm just saying he has several examples. To the extent he gets, like I say, he gets way down here into more explanations, and we don't want to drag this thing out so much because we have other things we want to look at. But I just wanted to show you the very last thing. I think this thing has something like 217 pages of it. But I just want to show you the last thing that he ends it with, which is this: work brings wins, wishing won't.
Exactly.
Exactly. So again, like I say, I'll send you this, and so you can post it along with this interview, so people will have this book. Because Richard wants this shared.
Interesting.
Yeah.
So, but the thing is, that, is this enough though? Is this book alone enough to enough background? So if the judge wants to,
I don't know, is it? No. See, again, it's not the book.
Yeah.
It's what you learn from it and the energy that you insert into the process.
Right. No, what I meant was, all right, I'll rephrase my question. Was this, hold on one second. Just 1 second. Ahead.
All right. Well, now, like I say, that's Richard's book. Real good information in there. And certainly understand where he's coming from. He's pretty much, working right within the system. He's out attorneying the attorneys. I mean, would you like to be an attorney and go against Richard Cornforth? God help you if you do. I know what's going to happen. And we have, I've known several mean, when I first started studying, there was a couple of guys there in the community where I was at. They were beating all the attorneys. The attorneys didn't stand a chance. And because, again, they had gone to the trouble to study the rules. They knew the rules better than the attorneys did. And so they were working, pretty good. So, it's very unusual to find an attorney that can meet the standard of people like Richard Cornforth. You just can't find them.
Well,
Very few.
it's because they study procedure mostly, right?
Yeah. But even in that situation, Richard is out proceduring
Right.
the attorneys. So anyway, let's go on to another. I wanted to share another book.
Okay.
Let's
See. It's hard to believe it's going to be 60-mile-an-hour winds today. It's like the calm before the storm right now. Okay.
Yeah, I know. I'm trying to move forward here rapidly so we can wrap this up. So you can
Yeah,
get
it's
going, take care of your business.
our regular time is good. No, I can't pick them up any earlier, so we're good to go. Adventures in Legal Land.
Yeah,
I like
this
the
is
name of this.
yeah. I like to listen to this fellow. I've seen him on the YouTubes, a couple of times. It's been a long time ago since he put anything out that I remember. But listen, he's just a logical, practical thinker.
Yeah.
I mean, if you want somebody to drain the swamp, get this guy to go do it.
Wow. Where
I mean,
black is
like,
white.
yeah,
Adventures in Legal Land, where black is white. See that, folks?
yeah. His name is Mark Stevens. I think he lived down there, or he did live down in Arizona. So his book is titled "Adventures in Legal Land, Where Black is White and White is Black, and Other Shocking Discoveries from America's Courtrooms."
Oh my goodness. Can't wait.
So he's got a sense of humor too. But the reason I like to listen to him because he's just practical. I mean, he just takes a look at the situation. He says, "Well, wait a minute, before we go down there, let's back up over here and see where all this come from." That's all he does. And so he's trying to, see if there's any factual reason to even be having the conversation about this. You see what I mean? So anyway, I just wanted to refer to this book. This book here is under copyright. But you can find it. It says this book is the intellectual property of the writer. If you wish to quote briefly from the text, you may feel free to do so, but only if you cite this book and its author's name as your source, which I've done.
Okay.
In all fairness, it says you may not, however, do so for profit, whether directly or indirectly, without first getting my express written consent to do so. And then if you want to go to the library, if you want to order his book, here's the ISBN number on it. So you can go to the library and look it up if it's in your library, and it might be. But if you want to order it, like through Amazon or through the, different ones, it should be fairly easy to find. I don't know how widely this book has been spread. Matter of fact, I can't remember where I got it from. It's been so dang long. Mm-hmm. Anyway, yeah, so I think he's down around Mesa.
Yeah, I like the bottom comment on there.
What's that? Oh, this book was written, edited, formatted, designed, illustrated, produced in the real world. Not in Legal Land. And like I say, that's what I like about, what he has to say, because, he's just practical. He is well grounded. He is solid in his logic. He's not making stuff up or doing all kinds of crazy things. He's saying, okay, well, let's take a look at what reality is. And so that's why I liked, listening to him. I corresponded with him one time. See, I can't remember. I think somebody, as I recall, somebody had asked him to come and give a lecture or a presentation on child services. Because people having their children stolen, all that kind of stuff, and I think a group had him come and give a speech about that, and so that may be on the internet still. And so based on that particular interview, I started to correspond with him on situations, that I had seen in that same regard. You might be able to find that on the internet. I have to go look for it, or if somebody can find that, maybe they can put it in the comment section so other people could go and watch that also. Anyway, I just wanted to kind of get it started a little bit. Then he adds acknowledgments, to this and that. But what I wanted to go to was page 35 and look at some of his practical, down to earth, solutions to how to look at things. All right. Let's see here.
Everyone should be raised on a farm, don't you think?
Well, at least be raised in a situation where they learn to be responsible as young people. I mean, you don't have to be raised on a farm, but even in a city, parents are raising children and they just let them run free and do whatever they want to do. That don't work.
Mm.
I mean, kids got to have chores. They have to have responsibilities. You have to be up. You have to have your hair combed, and all this kind of stuff. When you get home from school, I mean,
They don't like that.
well, too bad.
I know.
Too bad, because they still have to learn how to be responsible, because you can't trust an irresponsible child with anything.
Nope.
You can't trust them because, number one, they'll be a danger to themselves and they'll become a danger to other people.
Very good. Very well said, Winston. It's true.
If I tell a child don't just wander out in the street, or when you cross the street, look both ways. I mean, if they don't, what could happen to them?
Of course.
They could get hit and killed. And so, parents, if you live in the city or if you live in the country or wherever, you have to teach the young people to be responsible, or serious things could happen.
Well, that's when, you get into the argument about, and I never spanked my kids. I don't believe in spanking.
It don't work.
Yeah, but I mean, sometimes you got to, sometimes you have to get their attention, and and every once in a while, I mean, rarely, I would say, sometimes you have to kind of hit them upside the head, to kind of get their attention that they're not paying attention, and you have to listen to me, kind of thing, and then it goes in their head. I mean, it's so hard to get them to just listen, really.
Yeah.
Yeah.
Well, but you have to get through to them in some manner.
Yeah.
Because if you allow a child to grow up, to adulthood and stuff like that, then they have never learned responsibilities, and then you set them out onto society. I'm going to be upset with you.
You better find some way to get it through their heads. Yep.
Yeah, absolutely. I'm going to be upset with you if you send your kids out here.
Yeah.
I mean, for crying out loud, when I worked on a job in construction, I mean, where there was real danger. And I mean, we were using power tools, I mean, we were doing things, that were life threatening if they weren't done. And I had this one apprentice, man. And apparently he had not been taught responsibility when he was a young person. So I told him, I said, I want you to go up. Well, we were trying to put some tie downs on some trailers and stuff. And I said, go up on top of that trailer there, climb up that ladder. And I said, now hold this thing so that, because the wind was blowing, I said, hold that so the thing don't flop around. He got up there, didn't pay any attention. He didn't secure it was a metal strap, and the thing got to blowing in the wind, come along, cut my ear. I mean, I was on my way up that ladder.
Ooh.
I was going to pitch him off, because again, that kind of irresponsibility can get someone injured or hurt.
Yeah.
And if parents don't take the time or don't take the responsibility to teach their children responsibility, for crying out loud, don't send them out on a job like a construction job where someone could be injured due to irresponsibility and not paying attention to what you're told. Now we did have another fellow to come out as an apprentice, and I don't know why, but he was accident prone. If you could get hurt, or if he could get hurt, I never could figure out how it happened, but he was accident prone. And so he was simply put out of the apprenticeship program just because, if you was around him, somebody was going to get hurt. Why, we never could figure out, but he could not qualify. He was dangerous.
Mm.
And so again, like I say, parents, you raise their children, and they put them out in the world and everything, and they have, uh, the things they learned as young people are what they're going to do when they're adults, and so they need to learn responsibility and so forth. So you can't avoid that.
Yeah, maybe we could do a special report on parenting one day, Winston. That would be
Yeah,
interesting, huh?
I'd be a fine one to talk about that.
It would be good. It would be interesting. Some people need the guidance.
Well, okay,
Hard
that's
getting through some of these kids.
that's kind of beyond my scope of expertise, even though I have had a lot of it. But anyway, let's get on with this. This is
Okay.
again one of the chapters in Mark's book
Hmm.
that he wants to bring up here. So what he's saying here, he said never argue the merits.
Hmm.
Now, how many times have we said this? It's about procedure. It's not about merits. Anyway, he goes on to say, I personally don't care what a cop has actually charged me with. He just don't care what he charged me with. It might be speeding. It might be, he says, I think the opinion or charge, as they call it in legal land, is irrelevant. The real issue is his method of operation, that is physical violence and threats of physical violence. That's what Mark is saying is what is really at issue here. It's not whether you sped or run through a stop sign or something like that. He's saying, the threat of physical violence. Because they go ballistic on you. I mean, we had a guy up here in Portland some time ago, man. He, whatever he said to get the cop mad, he pulled him out through the window of the car and killed him. And so we always tell people, don't get into physical confrontation with traffic stops, because bad things can happen. I mean, I talked to a guy, he was from up in Boise, ex-Marine, about my age, and he had got into some kind of altercation or said something that the cop didn't like. He pulled him through his window of his car and beat him up. So don't be doing that. But anyway, so what Mark's saying here is, he says the real issue is his method of operation, that is physical violence.
Mm.
So there's no way to use physical violence and still maintain a pretense of fairness or good faith. One of them has to go.
True. I agree.
So, all right. Then he says, those who attack the rationale of the game and not the players are his most formidable adversaries.
Mm.
So that's what Mark is doing.
Right.
He's attacking the rationale of what's going on, and to make his points and to get the success and so forth that he has recorded.
Hmm.
He's very good. A lot of people try to get his help.
Mm.
Arguing whether or not I have a driver's license or ID takes the attention away from the fact that they are using physical violence and threats of physical violence. The whole situation is unfair, so why argue any alleged merit?
Hmm.
Who are they to force me or to do or say anything? That's the real issue. That's what he's saying here.
Okay.
He says a good analogy is a mobster convincing a businessman his business needs protection. He'll make him an offer he can't refuse. You know, maybe he'll threaten him with contempt of court.
Hmm.
However, the protection is not where your focus should be. It's the coercion, the taking of money by force. The so-called protection is the superficial part of this violent scheme. It gives the illusion of service, and there is less attention given to the taking of one's property by force. It's called sleight of hands. It's not the economy, it's coercion. Can you imagine arguing with a mobster that he failed to protect you? What's he going to do? Hit you on the head with a billy club or something. The point is, the actual charge is irrelevant because the nature and basis of the relationship is violence. As will be shown in later chapters, the central and most important issue here is, what is the nature of the relationship? If the relationship is based on violence, then why bother trying to reason with them?
Mm.
Complaining and rambling on about civil rights usually doesn't stop carjackers. Excuse me. After all, don't bureaucrats or the state, if you will, operate in the same manner as the mob? Let's say you want to start a business such as a barber shop. You open your shop and start cutting hair on a voluntary basis. Several weeks go by, and one day a bureaucrat strolls in and sees that instead of licenses hanging on the wall, there are pictures of prominent mobsters. He tells you that you need a license to be a barber. You tell him you've been profitably cutting hair for weeks with no complaints. Apparently, you can be a barber without a license. And then he makes you an offer you can't refuse.
Mm.
If you don't get the license, the city will shut you down. This means armed men will stop you violently if necessary from entering into a mutual voluntary agreement with your customers to cut their hair at a mutually acceptable negotiated price. What a crime. Such a sadistic animal doesn't deserve a trial.
Mm.
So again, he's getting down to the basis of what goes on. He's not talking about merits of what, whether the guy's a good barber or not a good barber.
Right.
But he's getting into contract with people to groom their hair, for a reasonable price. That's a private contract. And so now the bureaucrat comes in and says, well, you got to have a license to
Mm.
do that. And he said, why should I need a license?
Mm.
I can cut hair. Anyway, this is why I like to read, this book, because again, uh, he's cutting through all these problems. He's cutting through them and getting down to what's the basis of this. So if violence is what the basis of the situation is, let's deal with the violence
Mm.
and not the merits.
Mm-hmm.
And so the procedures that we would use to deal with the violence is what we're talking about here. So again, like I say, we're kind of moving along as quickly as possible. And I want to go into something else, but I recommend this book. I recommend this book. Like I say, you can find it. Perhaps you can find it on the internet. But he has been very successful because, like I say, for instance, he goes to help somebody, work through an IRS problem. I think he mentions this here later on in the book. He just, instead of arguing about, this or that, he just says, okay, well, what's the basis of the claim that you're making? Now, isn't that the same thing that we should be doing when we go into any kind of a court situation? Is there subject matter jurisdiction here or not? And what is the basis of your claim? And that's why, if you recall, when I did that presentation on habeas corpus,
Mm-hmm.
my position is that every case should start with habeas, every one of them,
Right.
to see if there's anything to talk about.
Right.
Because again, I use the example that, when you go to build a house, the first thing you do is you put in concrete footings, then you build a foundation wall, and then you start to build the house. And so without a foundation, a house just don't work. And so typically attorneys will start to build a house with no footing and foundation. And so if you want to defeat some of their things, go back and say, okay, well, where's the footing and foundation at? And that's why you would use habeas corpus right from the start. Or if you get into it, then you can do subpoena, deuces tecum, or you can do show cause hearings and all kinds of different things, to disprove subject matter jurisdiction.
Well, this is interesting because I think this is essentially what happened with the Rod Kloss case recently in the Supreme Court. Went in as an individual pro se, which rarely ever happens at the Supreme Court level, and he won.
Yeah.
Yeah, and it was about having your Second Amendment right, and that there wasn't proper notification for his case, which people can Google and look up, and maybe we'll talk about it at some point. But that's really significant. I would like to talk about that, maybe not today, but maybe another time.
Yeah, maybe we can.
To talk
But
about
but, but
as an
you see my point. Now, in my estimation, rather than go, I mean, I know Rob was trying to prove a point. That's what, and he's good at it.
Mhm.
Uh, but Cornforth's opinion is, hey, we can settle this, before in the same court, that it was. But I think Rob, was a Rod was trying to make a point, and that's why he pushed it as far as he did.
Right.
I mean, obviously he has more free time than me. Anyway, if you go through some more of this.
Well, I'm sorry, but it was a fundamental Second Amendment argument, and that's why it's so important, especially now that it's being decided, because of in light of what they're trying to do, there's the deep state trying to push another gun grab, and they're trying to use these false flag attacks to justify doing that. President Trump already said he's never going to allow the Second Amendment to be ratified or to be removed, or so it's just not going to happen. But this Rod Class case was about the Second Amendment.
Yeah.
Yeah. I'm sorry. So go ahead and continue.
No, like I say, of course, he tried that before the Supreme Court in Washington, D.C., which is simply a statutory court.
Mm-hmm.
The Second Amendment should really be decided in the Supreme Court in Pennsylvania. But okay, I won't get off on
Okay.
all
Right.
that.
Right.
But
Right.
anyway, what I'm pointing out in this book here is just good, practical, logical thinking. That's why I like this book so much. And then, some of the things he comes up with here, kind of, funny and stuff.
Well, he's right. It's very logical, and it's very
Yeah.
it's very intuitive, because do you really have a choice when someone stands there with a weapon that can be used against you if you don't comply with something they want? That's the problem. You're right. It's the threat of violence when they come to your car with a gun, and that's a good point. It's a good observation, definitely.
Yeah, that time I got pulled over, I told that funny story about, the policeman,
And he ran away from you.
no, he
No,
didn't
no.
run away. But anyway, he came up, and started, of course, they want to be the tough guy, And one of the questions, I didn't reveal this when I told the story, but one of the questions I asked him, I said, "Is your gun loaded?" In other words, can you draw it and shoot me?
Yeah.
And he said, "Yes." And I said, "Well, this is an unfair interchange because I don't have a gun."
Ooh, he must not have liked that.
Well, what I'm showing you is the
Yeah. Of
the
course, it's not
unfairness of the
egalitarian.
conversation that was going on there.
Completely
And
inequitable.
so I was under threat.
Yes.
He had a gun. He would have pulled it. He would have shot me.
Right.
And I wanted to make that clear to him that this is not a fair interchange because I don't have a gun.
Right.
You see what I mean?
Oh, there's a power. Yeah, no, it's a power. It's a intimidation through power. Yeah.
It was total intimidation. And so that's why, I went and did that commercial lean
Right.
because my gun was a loaded commercial lean. And his really the only solution. Of course, he didn't know it at the time, but really the only way he could have got out of that is if he had shot and killed me, because I was fixed to come.
Mm.
And so, a lot of the things I've mentioned in the past that we have done, using paper.
Mm-hmm.
I mean, like I say, the only way they could have stopped me from doing some of those things was simply shoot me and kill me. But they haven't done that because I don't think God's going to let them. But you see the unfair advantage you're going to get into when you're dealing with people
Absolutely.
who operate in violence.
Unfair advantage. Yep.
Yeah, it's an unfair advantage because, I don't have a gun. Well, and so, how am I going to defend myself against somebody that has a gun? Well, I'm going to act peaceably until I get them into a situation where I can start using my weapon of choice. That's what it amounts to. Anyway, I just want to show you the table of contents here. He's got some real good thoughts about a lot of these things. So, like I say, I highly recommend this book, for people, for just plain old simple logical thinking. That's all. So anyway, people can get this. Like I say, I can't give it away because it's not mine to give.
Mm-hmm.
Corn Forest is trying to give all his stuff away. but Mark, I think probably Mark, is trying to say, okay, if you're willing to pay for this information, you'll use it. See, this has been the position of Solutions in Commerce. If I just give all this information away, will people use it or not?
Mm-hmm.
And we found in the past that what people get for free, they don't treasure.
Mm-hmm. Appreciate.
And so we, like I say, we try to keep our price, at a minimum, so as many people as possible can have the information. But again,
Mhm.
people have come and said, well, we don't, like, let's say, for instance, the DVD or book or something. They say, well, we can't afford that.
Right.
And so our position is, well, what can you afford? And so if it's $10, if it's $15 or whatever,
Mhm.
we'll do the deal. We'll do the deal because we want them to invest, however much they have, so that they won't simply just get it and put it on the shelf and not look at it. We just wasted our time in doing that.
Mhm.
And so again, like I say, we've talked about, the GoldFish report. If you only got 5, if you only got 10, put it in so that you have an investment in what we're doing,
Mhm.
and you're more likely, if you have an investment in something, you're more likely to use the information than if you just got it for pure free. And so,
Absolutely.
think about that.
Hmm.
That's what I say. People listen to these reports and everything. My God Almighty, the information we put out on these country road report is phenomenal. I have to say that it is.
Yeah.
But go ahead and throw in a 5 or a 10, or if you got more, throw that into it, because that's an investment on your part that connects you. You're sending your energy to combine with our energy.
Could you take it off a screen share? Because they're
Oh
just
yeah,
looking
I'm
at
sorry.
this page. They can't see us really, and it makes it hard to connect with the message if they can't really look at us.
Yeah, but like I say, if people have no commitment to
Hmm.
something, then they're less likely to be able to really have the benefit from it. Now, like I say, if you only got a 5 or you got a 10, go ahead and put it into the pot, because that's your investment. The scripture. I mean, it was I think that one of the parables that Jesus came out about the widow's mite,
Mm.
and he said rich people give all these large sums and everything, but he says whose whose contribution is greater, the rich man who gave a small portion of his wealth versus the poor woman who only had a penny,
Mm.
but she gave everything she had. You see what I mean?
Mm.
And so, people should think about, what kind of commitment are they making to the message that the GoldFish report is putting out. Now, if you got a 5 or 10, or if you got 100 or 200, I don't care what you got. But if you want to have the best effect from what the GoldFish report has to offer, put a little something into it, and I think you'll be better connected, and profit more from it. So
Right.
again, like I say, this whole thing, GoldFish report is viewer supported, and so the viewers need to support it.
Well, we have a new Patreon site too, so I
Yeah,
mean, it's very helpful for people if they want to make an ongoing contribution. They could do it there too.
yeah,
Thanks for that mention, because it is an exchange of energy, and
it
there it
is.
has to be. It definitely has. There has to be an exchange of energy. We don't have corporate sponsors. We don't have any sponsors. It's just viewer supported. So
Yeah.
I do this full time, and there's no salary. So it is something that I can't do forever. And so
Nope.
that's the reality of it, is the Goldfish report can't sustain itself without viewer help. And it's really very that important and that critical, that if people do like the content, that they do make that that they contribute, they make that they participate and exchange, have some kind of exchange of energy with that. So thanks, Winston. Thanks
Yeah,
for
yeah.
that.
Now there's one, we're kind of running up on time, and there's one more thing that we tried to experiment with. I do have some the clip I had mentioned, I think last time, a particular DVD we had produced, which is called a fresh look at tactics. It was actually a result of, we had done some webinar type things over a period of 2 or 3 months between Spencer and myself, where we were trying to reveal certain things about court and tactics, and just interchanges in general.
Mm.
And then so we recorded those audio, but the problem was, because it was over a 2 or 3 month period, it was kind of just a little bit disjointed. So what we did is we sat down and said, okay, let's get in front of the camera, And so let's put all this together. And so we had tried to do a screen share to see if the voices and everything would work. It didn't work too well, but I will just screen share a little bit of it just so that people will see, who it is they're dealing with. And that was, we had a little bit of a conversation there. Court situations keep coming up.
Can you screen share that?
Can you hear it at all?
Yeah, but we can't see it. You have to screen share?
Oh, I'm sorry.
It's okay.
Wait a minute. Let me, all right.
I was able to hear it though, so that's good.
Oh, you were?
Yeah, the sound of it's not going to be that great, folks, so don't complain about it. There's nothing we can do. It's just a function of how the video conferencing software that we use, but you might be able to hear some of it. Nothing actually. We're not hearing. There's no sound coming through at all. Sorry about that, Winston.
No, that's okay. Like I say, we got, we could probably figure it out if we had time. But what I was wanting to do is to show this particular DVD. People from time to time ask about this or that and the other. And so I wanted to show, the quality of what you're going to get as far as the audio and visual and stuff like that. And I wanted to show, some short clips as an example of what you can expect, from that particular DVD. And for those who are dealing in certain court situations and whatnot, this may be profitable to you. And so you can go on the website and you can look that up. Let me see. Let me get this sound back the way we had it, so I don't blast people out. Does it sound good now?
Can you say something?
Yeah, talk.
Yeah, it's I'm not quite sure how it's going to come out, but no, I can't hear you at all now. Yeah.
Yeah, I might have blasted.
That's better. No.
I can turn it up.
It was better before.
How about now?
I can hear you, but it's your volume is really low now.
Oh man, that's too bad.
Yeah, it's not the best sound software, sadly. It's not that sophisticated. So
now.
Yeah, that's better. Whatever you just did, you're much better. Yeah.
Okay, well, on that DVD, what we're breaking it down into 3 parts. The first part had to do with, the theory behind some of the things that we work with. Then the second part had to do with a little bit of technology. And then the third part of it were basically anecdotes of how we had handled things in certain courts in certain situations. So just like Mark Stevens, I was talking about there a minute ago, Spencer is a very solid thinker. And it's kind of funny, at the start of the thing, I just started it out and I said, well, Spencer, I understand that you're a high school dropout. He said, no, he said, I didn't drop out. He said, I fired the school.
Oh my God, that's funny. He fired the school.
He fired the school. So they weren't giving him what he wanted. So he fired the school. He didn't drop out. He fired him.
Whoa.
But anyway, that's the kind of thought process, that people like Spencer and Mark and and even Richard and myself try to work with, is that we try to analyze what things really are. And when we, when you can be grounded and operate and understand how to live in the private, then you can start to see how the private and the public can work together. If you only understand the public, you're going to be forever and a day chasing your tail around. That's just what happens. And so really to operate properly, out in the public, you have to understand what reality is. See, I ask people, I said, I mean, when we start to talk about shadows, what creates the shadow? I said, just go out and stand in the yard with the sun up in the sky, and you'll cast a shadow. But if the reality is not standing there, there will not be a shadow. And so when we start to talk about the public, which is in fact just a shadow, the reality or the private side must be there, or there's not any existence. We have simply adopted fictions.
Makes sense.
In our commerce so that we can carry it on, because when we start to talk about weights and measures,
Oh, right, right.
we just created a fiction. So you go out to your garden and you pick out a great big old watermelon and you bring it in the house and you eat it and you know what it is. But if you want to take it down to the market, to the farmer's market, then what do you have to do? You got to weigh it. So this watermelon here weighs 10 pounds. And I'm going to charge you 25 cents a pound if you want to buy my watermelon. We just created a fiction. But you have to do that unless you want to use the barter system. But in our present commercial system, that's just how we have to do things. So it's the same way in the courts. It's the same way in government. It's the same way with bureaucracy. It's all these kind of things. If we prefer to use weights and measures, if we prefer to use fiction in our commerce, this is just how we have to do it. Unfortunately, most people get locked into the fiction side or the public side and never realize that if you're not standing outside in the sun, you'll never have a shadow. And shadows are very good. I mean, if you stand in the sun too long without an umbrella or something, or you're going to get sunburned. But I think you see my point.
Yeah.
And so like I say, we have spent a lot of time trying to demonstrate to people about what we call the private side or the real portion of life. And but again, in order to operate, we got 8 billion people on the planet, for crying out loud. How can you do barter with 8 billion people? It's impossible. So we had to go into fiction in our commerce and everything. So I'm not against it, but what I've tried to do as Solutions in Commerce is to help people understand it so they will not be taken advantage of. And it's the same thing as what we was talking about here today with some of this court stuff, with void judgments and what Mark had to show and all these kind of things. So that's pretty much what I wanted to put across today. And I know we're getting pretty close to 2 hours here, so I don't want to hold you up. I know you have children you have to attend to and whatnot. So.
Well, no, thank you, Winston. This is very helpful. I think, for me, I'm just always trying to think of the viewer and connecting the dots and making sure I understand it so I can write it up for on the description section of the video. So thank you again. Now, Winston, if people have any questions, they can just contact you on your website. Is that right?
Yeah, I just send an email and ask about it. I've gotten quite a few emails. It might take me 2 or 3 days to get to all of them, but eventually I'll get to the emails and answer your questions and so forth. But I will send this Corn Forest book to you so you can post it along with it, and then people just download that and study it. When I send it to you, I won't send it with all the highlighted areas.
Okay.
I like for people to get their own highlighting done. The things they think are important.
True.
So it'll just be a regular thing. So people can work from that.
Well, thank you, Winston. And so then I'll have those links in the description section of the video. And also, don't forget to look for us on BitChute, because in the event that our YouTube channel is interfered with in any way or deleted, you can always find our videos on BitChute as well. And of course, our other sites. It will be a long, post in the disclaimer section with all our other resources. So, but just so our viewers know, all of our country roads, all of our POTUS reports, all of our interviews are all backed up. We have them all we don't use YouTube to do the recording itself. We have another recording mechanism, which means we have all of our archives, we have all of our original work. So should YouTube do that unthinkable act, and they are doing it, but should they do it to us, we will be backed up and we will have access to all of our reports and we will get them back up. So,
Good.
yeah, so I have, I think that, this is the reality of the world we're living in today. So we have to be prepared. Winston, thank you so much. I mean, for taking your time and going through all of this all the time, every week for our viewers. It's really very kind-hearted of you, because you receive no, when people do end up, some people do buy the technology for themselves, but you spend your time here sitting with me as I do. We do this as volunteers. So, I do thank you, and, I do appreciate that if there is an exchange, there should be an energy exchange of some kind between people who receive the kind of information that Winston is providing, because it is there to benefit you and enrich your life, and keep you out of trouble if possible.
Well, in that respect, like I say, I feel like it's my duty to do this. I came onto the planet. Some things I've been able to accomplish, other things I haven't been able to accomplish, have been blocked or whatever. So this is a good way to be service to others oriented.
Right.
And again, folks, watch
Mhm.
for this energy that's coming in. This is going to be phenomenal. What's fixing to get here, and I think perhaps, perhaps by the time you hear this, you might have already got struck.
Yeah. So you're talking about the energy that's coming in this weekend. It's supposed to be
Yeah.
some pretty interesting energy. Yeah. And also, folks, we're going to be doing our 200th Goldfish report. Will be well, by the time you see this, it will already be posted. So we just wanted you to keep a lookout for that. Um, and we hope it'll remain posted. We don't know what's going to happen, as far as YouTube. But I just want to thank our viewers. Hold on one second. Okay. um, so, folks, all this information is going to be in the description section of the video. Look for it. Look for our 200th special with Winston, myself, Sergeant Dan McBolin from the U.S. Air Force, and our friend from the UK, Miles Johnston. Now, we're all experiencing these crazy weather patterns, so it's going to be a real interesting thing to see that we all come together. We're in 5 different time zones, and we're going to be trying to get this video working and internet working so that we can all participate in this report. And it's going to be on MK Ultra, mind control, and disclosure of these programs, and how these programs have forwarded agendas that were not in the best interest of humanity, and how right now it seems that the deep state, this is really what's been behind the deep state and helping them to promote their nefarious agenda of the New World Order. And we will discuss that in this 200th Goldfish Report. And we're happy that you're there with us celebrating this and being there with us, because we're here doing it for you. So thank you so much for viewing. All these links will be in our description section. And Winston, good to see you, and I'll see you in another hour or so for our next report. And and
Yeah.
we'll be back a little bit later, and of course we will always be back next week with another episode of Country Roads. So stay tuned, folks. We'll also be back on Monday with our POTUS report with Dr. Jim Fetzer again. And, we can expect probably that's going to be banned, but we'll see. So anyway, we have a nice weekend to everybody. Enjoy these reports that are coming out, and we'll see you all next time. Thanks for viewing, and this concludes this edition of the Goldfish Report.